Okay, good morning. We are going to get started. I'm going to start. This is Eric Becker from Cummins & White. I'll be the presenter today, but before I get started with our topic, I'd like to have Gary Arch say a few words about our webinar and what we're trying to achieve here for clients of BMR. Gary?
Great. Thanks, Eric. This is Gary from BMR Insurance, and happy to partner with Eric Becker and Cummins & White to do some employment information for our clients. Hopefully you'll find this very interesting. I was able to join a webinar last month that I found extremely helpful and thought it would be a good idea to share some of the information with our clients. So you can look forward to a few more webinars of similar topics throughout 2015. We'll send out an email for that, and look forward to today's with Eric. So I'll turn it back over to you, Eric.
Great. Thank you, Gary. And I do want to mention that our intent is to have a series of webinars going forward on employment-related topics, so that if there's a topic that you feel would be helpful for your business, something that would be helpful to get an explanation on, please feel free to send me an email or Gary an email and suggest topics. We're always open to any suggestions that you may have. Let's start by talking today about our topic for this webinar, which is using independent contractors and how to protect your company from liability. Independent contractor status, it has been a hot topic in employment law circles for probably the past 5 to 10 years. As we'll talk about today, there's a number of different things that have gone on in this area, including legislation and a lot of litigation, not only from individual employees, but also from state agencies and federal agencies seeking to collect taxes, particularly from employers who use a lot of independent contractors. So what we're really going to be focusing on today is, if you have independent contractors that you're utilizing, what are the things you need to watch out for? What are the things that distinguish those independent contractors from employees, and whether or not all of those criteria, or at least a significant portion of them, are met with your independent contractors? And what are some of the best practices that you can undertake to make sure that you have a viable defense in case somebody down the road claims, I wasn't an independent contractor, I was an employee, or one of the agencies, whether it's a state or federal agency, brings some sort of audit or there's some sort of claim filed where they're looking for back taxes, they're looking for unemployment contributions, etc. So let's talk about our topics. First of all, we're going to talk about, why does it matter? Why does it matter whether somebody's classified as an employee or independent contractor? What's the big deal here? I'm going to spend a little bit of time talking about what are the characteristics of an employee. What makes an employee classified as an employee under the law? And then, of course, we'll also talk about the characteristics of independent contractors. What makes somebody an independent contractor rather than an employee under the law? I want to spend a little bit of time talking about potential liabilities for misclassification of independent contractor or employees as independent contractors, particularly with some new legislation that went into effect here in California a couple of years ago. And there's some very significant penalties that are possible for employers for misclassifying employees, as well as, of course, lawsuits and other types of claims filed by the state or the federal government. And finally, we'll talk about our best practices for defending independent contractor status among employees. So let's talk about, first, employees or independent contractors. Why does it matter? The biggest reason it matters is that most employment laws don't apply to independent contractors. So all the things that a California employer has to comply with, whether that's minimum wage, meal and rest periods, overtime, sending out wage statements with each paycheck that set forth the hours worked and the overtime worked and the pay and all of those other things. All of those things that employers are required to do for employees, they're not required to do for independent contractors. And so a lot of employers see a significant advantage in classifying people as independent contractors just to get around those requirements. Secondly, there's no such thing as wrongful termination when it comes to an independent contractor. Wrongful termination is a creature of employment. And if someone feels that they were fired or let go and there was something wrong done by the employer, whether that's discrimination or anything else, they can file a claim against that employer. But with an independent contractor, if the relationship gets terminated, there is no recourse for wrongful termination. There is no recourse for discrimination, generally speaking. Now, there are a couple of exceptions. First of all, and this is something that's not very widely known, but independent contractors are covered under California's laws prohibiting sexual harassment. So if an independent contractor says, hey, I was subjected to sexual harassment while I was working at that particular company or for that particular company, they can still file a claim against the individual or the company, even though they're independent contractors. And there's one exception in discrimination laws. Most discrimination laws don't apply to independent contractors, but there is a claim for a violation of civil rights under Section 1981 of the U.S. Code, so it's a federal claim, and independent contractors can bring those types of claims. But generally speaking, the things that employers have to deal with, people claiming disability discrimination and claiming that they were terminated because they filed a wrongful termination or workers' compensation claim, none of those things apply to independent contractors. So that's a significant advantage for employers. Secondly, and very importantly as well, employment taxes aren't applicable to independent contractors. So as you know, if you have an independent contractor, you're not taking out taxes for that independent contractor, but you're also not paying the FICA tax. You're also not paying the UI tax, the Medicare tax. The employer is off the hook for a significant portion of their tax liability. So again, major advantage for employers. There's also flexibility in structuring payment for an independent contractor. Versus with an employee, you're pretty much stuck with paying him either hourly or salary if they're exempt, or some sort of piece rate. But with an independent contractor, you can pay them, for example, by project. Hey, I'm not paying you for how long this is going to take you to finish this project. I'm paying you a flat rate. This is what you get. You're doing this work for me. You couldn't do that with an employee. Independent contractors generally are not eligible for workers' compensation coverage under the employer's policy. There are some circumstances where people who are kind of hybrid independent contractors are eligible to be placed under the employer's workers' compensation policy. One example of that is real estate agents. They're kind of independent contractors, but kind of not. So you see a lot of real estate firms that actually put real estate brokers on their workers' comp policy. But generally speaking, when you have an independent contractor, they're not going to be subject to your workers' compensation policy, which means, of course, your rates aren't as high, and if they have an injury related to the work they perform for you, they can't file a workers' comp claim and boost your mod rating. Generally, independent contractors are also responsible for the expenses related to performing the work. If an independent contractor has to drive a certain distance as part of the project, if an independent contractor has to buy software to install on their own computer in order to do a project, if they have to buy a certain tool, that's on the independent contractor. Now, from a practical standpoint, sometimes employers who have independent contractor agreements agree to reimburse some of the expenses, but that's not a requirement. And with many independent contractors, it's understood as part of the agreement that whatever expenses are required to perform those services, that's the independent contractor's responsibility. The difference with employment is that with an employee, the employer is required to reimburse all expenses under Labor Code Section 2802, which says that the employer has to indemnify the employee for anything they incur as part of employment. The most common that we see, of course, is that if employees are driving as part of their job, not their commute, but driving in between job sites, you have to reimburse them for their mileage, their depreciation, et cetera. Most people do that by the IRS gas rate. So with an employee, you have to do that. With an independent contractor, you don't. So those are some of the important reasons why it matters whether or not you classify someone as an independent contractor or an employee. Let's talk now about the characteristics of employee status. And before I get into this, I do want to mention that we do have a chat function. So if you do have a question as we go through the process, please type it into the chat box. If I don't get it while we're in the process of going through the slides, I will certainly get to it at the end of the presentation. So please feel free to use that function if you have any questions. And of course, at the end of the session, if you have any questions, you can type those into the chat box as well, or you can always email me. So let's talk about characteristics of employee status. What makes someone an employee versus potentially an independent contractor? The biggest factor that is looked at by the courts, by the administrative agencies that oversee independent contractor and employee status, is that with an employee, the employer has the power to control the worker and the means and the manner of how the work is performed. In other words, the employer retains control over that employee when they're coming to work, how they're doing the work. So let's look at some of these specific examples. Okay? If you have an employee, generally speaking, they've got a time, they've got to report to work, and they have to remain there until the employer releases them. They're under the control of the employer. The idea is I'm paying you to be here from 9 a.m. to 5 p.m., except for that 30-minute meal period where you're released to do whatever you want, because I'm not paying you. You're under my control. Secondly, an employee must follow company policies and rules or face termination. That is a big characteristic of an employee. If an employee joins your company, what do they typically have to do? Sign an employee handbook that sets out all the rules and all the policies, and what's the consequence if they fail to follow the rules? They'll be terminated. That's a function of at-will employment. The employer retains the right, the control, to terminate that employee at any time for any reason. And there's a recent Supreme Court case here in California where the court pointed specifically to that and said, hey, if the employer says this is an at-will relationship where I can terminate you at any time for any reason, and you violate my rules and I terminate you, that's control. That's what makes somebody an employee. Next, employees must account for their time worked. Of course, with exempt employees who are salaried, generally speaking, they're not going to account for their time worked, but they have to account for when they're at the employer's work site. They have to keep their manager or their boss apprised of when they're there, when they're not there. And of course, with an hourly employee, typically they're going to be clocking in, clocking out, using some sort of timekeeping system to keep track of their hours worked. That makes somebody an employee. And the work they perform is typically performed under the direction and instruction and the guidance of the employer. It's not a situation in most circumstances where the employer says, look, I need 500 widgets, you figure out how to make them. There's usually instructions, there's guidelines that the employee has to follow in order to accomplish the tasks that the employer sets out for them. That factor is part of the power of control that the employer has over the employee, and that is a big part of what makes somebody an employee. They're performing work under the instruction of the employer. Next, a big characteristic of employee status is that the employee performs work that is core to the business of the employer. And what we mean by that is that the employee is involved in production of goods or provision of services that's sold to customers. That's what the business does. So if it's a widget manufacturer, someone who's in that process of making the widgets or boxing up the widgets and shipping them or quality checking the widgets. Those are all functions that are core to what the business is trying to do, manufacture and sell widgets. Likewise, if you have a service business, if the business, for example, is an architecture firm, what's core to the business? Meeting with customers, going through their plans, developing architectural plans for those customers that the customer is going to pay for. So people that are involved in that process of developing the architectural plans are core to the business. And employees generally are performing work that is part of what the business is in business for, versus something ancillary that is really related to the operation of the business rather than what the business is in business for, as we'll talk about with independent contractors. A next characteristic of employees is that employees utilize the workplace of the employer. That's where they perform the work. They use the tools that are provided by the employer and the equipment provided by the employer. So a typical employee is going to show up at the work site, or maybe they're going to different work sites. And a lot of times they're going to be driving a company vehicle, or they're given tools to use at these various work sites by the employer, with some exceptions. Sometimes mechanics have to get their own tools, but they're using the copier, they're using the break room, they're using what the employer provides. That is the characteristic of employee status. Here's a big point that a lot of times is a critical determining factor between employee and independent contractor status. And that is that employees aren't going to profit or suffer a loss depending on their business acumen. And what we mean by that is that when you're an employee of a company, if the company doesn't do well, if the company doesn't sell enough widgets, or they sell widgets at a loss, and the company loses money for that particular year, the employee, him or herself, isn't going to suffer that loss directly. They are not going to be in the red for the year. And conversely, if the employer does well, if the employer gets a big new contract and they're selling widgets like crazy and now they're making a profit, the employee, him or herself, doesn't directly profit. That's the company's profit. Now, the company may share some of those profits, but at the end of the day, it's the company that profits, not the employee. And that is a characteristic of employee status versus independent contractor status, which we're going to talk about in a second. Next, employees are usually at will. They are hired for an unspecified term. Every once in a while you have temporary employees where you say, hey, I'm hiring you for a month, or I'm hiring you for 2 months, and that's it. But for the most part, when employees are hired, they're hired for an unspecified term. You're going to work here as long as we decide we want you to continue working here, and as long as you decide you want to continue working here, you're going to stay. And that's what at-will employment is, versus a specified term, which is something you commonly see in independent contractor agreements. Next, employees are paid on an hourly salary or piece rate versus any type of flat rate, another characteristic of employment. And going along with that, typically employees are issued a W-2 form. That's a tax form that is used for employment. And so if you have employees, that's what they're going to get, and that's a characteristic. Next, and this is something that a lot of people miss in this whole thing between determining whether someone's an employee or an independent contractor. A lot of times, employers have confidentiality agreements or non-disclosure agreements. Maybe it's a standalone agreement, maybe it's in the employee handbook. But as part of that, employers often say that when an employee works for them, anything they produce is a work for hire, meaning that any drawings they come up with, plans, ideas, etc., that all belongs to the employer. They are works for hire. And the employee gives up any rights they may have to ownership over those ideas or plans or inventions that they've developed while they're in employment. And in California, in particular, there is a code section that says, under the unemployment code, that when an employee is governed by a works-for-hire agreement, that is a characteristic of employment versus independent contractor status. So if you've got an independent contractor that's covered by a works-for-hire agreement, presumptively they are not an independent contractor, they're an employee. So it's very, very important that employers look at the documents that they give to independent contractors to make sure that there's no works-for-hire language in there. Because once you have it in there, pretty much you've destroyed their independent contractor status. Okay, let's talk about independent contractors. What are the characteristics of an independent contractor versus an employee? First, unlike an employee, the independent contractor controls the manner and the method of performing the work. So instead of having a 9 to 5 schedule where I'm going to show up at work at 9 and I'm going to work till 5 and I'm going to work Monday through Friday, and on Saturdays I'm going to work 8 to 12. No, with an independent contractor, the work they perform is performed based on the schedule of the independent contractor. So with an independent contractor, basically the hiring company says, look, this is what I want you to do. You figure out when you're going to do it. Maybe there's a deadline, and there's nothing that destroys independent contractor status with having a general deadline. Hey, I need this done in 2 weeks. I need this done in a month. But if the independent contractor decides they're going to do it from 7 p.m. to midnight every night, as long as they get the project done, that's fine. That's what defines them as an independent contractor. They've got that control to determine when they're going to perform that work. And they're also going to determine how best to achieve the results desired by the company. Unlike an employee that's going to basically be working under the direction of a supervisor, under the direction of a manual, guidelines, etc., it's the independent contractor who makes the decisions over how am I going to get from point A to point B and achieve the result that the company is looking for. So with an independent contractor, what you typically see is that the company says, look, let's take the example of a bookkeeper. We need to have the books reconciled, the bank statements reconciled, the books done by the end of the month each month. We're not going to tell you how to do it. We're not going to tell you the proper procedures for doing it. That's something that we hired you for. You have that skill. You have that expertise. You figure out how to do it. Just get it done. As opposed to maybe a bookkeeper who works for the employer as an employee, they're working under the direction of a CFO. They're going to have specific instructions. No, every day you need to have this done. You need to have this done. These are the tasks I expect you to perform. With an independent contractor, it's just, here's the result. You figure out how to get there. Next, an independent contractor performs work that is related to the general operation of the business, as opposed to the core of the business like we talked about with employees. So independent contractors, a characteristic is they're performing work that is related to, for example, construction and repair of business property. If you need to have the roof fixed, you call a roofing company. They come in. They're charged with fixing the roof. We need to have the roof fixed in the next 2 weeks. You guys figure out how to do it. They fix the roof. Then they're done. That's not something that's core to the business. That's not something that's part of the production or service. It's just, hey, we need to have the roof fixed on our building. Finances. A lot of times independent contractors, especially for small companies, are bookkeepers, like I talked about. We don't want to have a CFO or an accountant on staff, so we're going to hire an accountant, and they're going to do all our financial reports, our bank reconciliation, etc. That's not something that's core to the business. It's part of what's needed to generally operate the business, but it's not what the business does, what they're in the business of, selling or providing particular service. Other examples, employee benefits providers. management consultants, trainers that are brought in to provide specific training. Those are all things that are related to the general operation, but they're not part of the core. And that's characteristic of an independent contractor versus somebody who's doing a job that's part of what the business is in business to do. Next characteristics. Typically, independent contractors provide their own tools, their own equipment, and their own workplace. Now, that's not to say that an independent contractor can't perform work at the workplace of the employer. That's very common. But it's based on necessity. Hey, I need to be at the workplace of the employer because I'm conducting a training session, and that's the place the employer wants to do it. It's based on necessity rather than the employer's requirement that, hey, no matter what work you do, you're going to do it here. So, for example, in a training situation, the trainer may have to perform the work at the work site, the actual training, but developing all the PowerPoint slides and everything else for the training, they can do at home. The employer doesn't have a requirement that it all be done while they're at the employer's workplace. Next, unlike employees, independent contractors typically stand to profit or they risk loss from the engagement. So when you're talking about an independent contractor, what are they typically doing? They're figuring out, okay, how much should I charge? How much should I bid? If I overbid, am I going to lose out? If I underbid, will I end up taking a loss on this project? The independent contractor has to make those kind of decisions that employees don't make. They've got to figure out, okay, if we're going to do this project, we're going to fix this roof, how are we going to control our costs? Maybe I need to get the best deal possible from the roofing supply company. And if I can get a great deal from the roofing supply company for all the things I need to fix this roof, I'm going to make money on this bid. Also, the efficiency in completing the task of the project. Hey, if I can get this done with 3 guys rather than 4 guys, and I only have to pay 3 guys, I'm going to stand to make a profit. If I have to bring in a 4th guy, maybe I'm going to have a loss. Those are all characteristics of an independent contractor versus an employee. They can end up losing or making money based on how well they manage the engagement. Next, and a really, really big point, independent contractors have an independent contractor agreement in writing with the company. It's a major characteristic, to say the least, that there's some sort of written agreement between the company and the independent contractor. And as you know, with employees, typically there's no written employment contract. You have your handbook, says they're at will, there's no contract of employment, etc. But independent contractors typically have some sort of agreement with the company in writing that sets forth the terms of the engagement. And I'll talk a little bit more later on about what are some of the important things to have in an independent contractor agreement. But needless to say, when it comes to characteristics that a court or the administrative agencies are going to look for, they're going to look for that written agreement. Next, independent contractors typically invoice for their services rather than submit a time card. So an independent contractor would usually send some sort of bill, invoice to the company for services rendered or for the project as a whole, as opposed to every week turning in a timesheet and saying, pay me based on my timesheet. So again, we'll talk about a little bit more under best practices how you do that, where you're going to make it more likely that people will be considered independent contractors. But that's a major characteristic as well. Next, independent contractors typically recognize or agree that they're not an employee. Usually that's contained in the written independent contractor agreement. The independent contractor says, I understand, I agree, and the company understands and agrees, I'm not an employee. Typically, independent contractors also maintain their own insurance coverage. They're going to have general business liability insurance. They may have property insurance to insure their property that they're using in performing services. And if they've got their own employees, they're going to have their own workers' compensation insurance for any of their employees. versus an employee, they're insured by the employer. They're covered under the umbrella policies that the employer has, whether that's workers' compensation or general business liability. That's part of the employer's duty to indemnify the employee. Independent contractors advertise their services to the public. This is a major characteristic that differentiates ICs from employees. An IC typically is going to have some sort of mechanism to get the word out to various companies that, hey, hire me, hire my company. If it's ABC Roofing Company, maybe they've got a Yellow Pages ad, maybe they've got a website, they've got something that holds themselves out to the public as a company for hire to fix roofs, versus an employee who's working generally for one employer. They don't advertise to other employers, hey, I work over here at the architecture firm, but if you want to hire me for a project, I'll be glad to work for you as well. Independent contractors typically provide services to more than one company. Now, it's not to say that someone can be an exclusive independent contractor and they lose employment status. It is possible for an independent contractor just to work for one company. But generally, a characteristic of an independent contractor is that they're going to provide services to multiple companies. Let's talk about a couple of irrelevant criteria. This is one I hear quite often, that, hey, this person is a 1099, and because they're a 1099 and we issue them 1099 forms, therefore they're an independent contractor. And 1099 status actually follows from proper classification of somebody as an independent contractor. Just because you issue a 1099 does not make that person automatically an independent contractor. It's the reverse. Because they're an independent contractor, you issue them a 1099. Now, while issuance of a W-2 is definitely a characteristic of employee status, issuing of a 1099 itself has no bearing on whether or not that person is properly classified. So don't fall into the trap of thinking, well, just because I issue them a 1099, they're automatically an independent contractor. All the other factors that we talked about previously is what's going to determine whether or not they're properly classified, not whether or not they were issued a 1099. Another thing I commonly see is people, companies say, hey, this individual that we have as an independent contractor has incorporated, so therefore they have to be an independent contractor. And whether somebody is incorporated, whether they're an LLC, whether they're a DBA, whether they're a sole proprietorship, none of that matters in terms of determining independent contractor status. Just because somebody incorporates and they have their own company doesn't mean they can't be an employee. It depends on all the other characteristics that we talked about previously. So let's talk about how independent contractor status is evaluated in California. First of all, it's important to recognize that there is a presumption in the labor code that anybody who works is an employee. So whoever is asserting that someone is an independent contractor, typically it's a company or an employer who's saying, yeah, this person was an independent contractor. You've got the burden of proof to overcome that presumption. So it's not a situation where the individual who's saying, hey, I'm an employee, has to prove they're an employee. It's the reverse. The company's got to prove they're an independent contractor. As we talked about, the control factor is the most important factor. The courts are going to consider all the different factors, but they're going to look at control most carefully. The more control the employer exhibits over that worker, the more likely it is that person, that worker, is going to be considered an employee. Now, in California, you don't need to meet all the characteristics of independent contractor status in order to qualify. There can be things missing. You can have somebody who doesn't advertise to the public, but they meet all the other characteristics, And generally speaking, the courts are going to say, hey, you know, on the balance, totality of the circumstances, this looks like an independent contractor. Now understand, there's no perfect science here. You can have one agency, and this has happened a number of times. Let's say the Department of Labor Standards Enforcement. Somebody files a wage claim. Somebody says, hey, I wasn't paid overtime. And the company says, wait a minute, you're not entitled to overtime, you're an independent contractor. And the Department of Labor Standards Enforcement investigates, and they find, yes, this person was an independent contractor, they are not entitled to overtime. But in the same time frame, that independent contractor has also filed an unemployment claim, saying, hey, I was laid off, I'm owed unemployment. And the employer says, no, there's no unemployment here. You are an independent contractor, not an employee. The EDD, the Employment Development Department, investigates and decides, no, we think this was an employee. That is not uncommon. So just understand that, especially if not all the characteristics are there, if there's some characteristics of employment and some characteristics of independent contractor status, you may end up with different decisions from different bodies. Also, the initial agreement over independent contractor status is not determinative. In other words, somebody can say at the outset, hey, yes, I agree, I'm an independent contractor, but over time, the relationship morphs into something that looks more like employment, and it's not an absolute defense to say, oh, this person agreed they're an independent contractor at the outset. If the situation changed, if the facts changed, it could end up being that that person, for some period of their engagement, is determined to be an employee. So, what is the liability for misclassifying employees as independent contractors? First of all, there is a labor code section in California, section 226.8, that went into effect in 2013, that makes misclassification of employees as independent contractors unlawful. And the penalties are pretty severe. There's a penalty of $5,000 to $15,000 for each infraction. Each misclassification of somebody as an independent contractor can lead to that penalty. And then there's a higher penalty if it's found that there's a pattern and practice of misclassification by a company. So for instance, you have a company that has over time classified multiple people as independent contractors when really they should have been employees. The state can come down and issue a penalty of up to $25,000 for this pattern and practice. So these are pretty significant penalties that are out there for employers if they misclassify someone as an independent contractor. Secondly, there's liability as an uninsured employer under workers' compensation. If you've got someone who you've classified as an independent contractor and really their employee and they get hurt on the job, the employer can be liable for paying all of their medical costs and their benefits for the time period that they are injured and out of work. And that could be a pretty significant number. Sometimes medical costs can go up to hundreds of thousands of dollars, and potentially the employer is on the hook. So it's really important in looking at your independent contractors to make sure that they're not misclassified. Because if they're employees, you want them under your workers' compensation policy to protect you from that potential liability. Also, misclassified employees can file individual or class action lawsuits for employment claims. Typically, this comes up when independent contractor arrangement is terminated for whatever reason. The independent contractor thinks, I really got a raw deal here, and they go to a plaintiff's attorney and they say, hey, I was this independent contractor for this company for 3 years, and now they let me go. Do I have any claims? And the plaintiff's attorney takes a look at it and says, okay, tell me what you did for the company. Tell me, did you have a written independent contractor agreement? Did the employer control your work schedule, etc.? And they do an analysis and they say, oh boy, you were an employee. And if you were an employee, how many hours did you work a day? Oh, I worked at least 10, 11 hours a day. Well, you're owed overtime for that. And did you ever get a meal period? No, they never gave me a meal period. Okay, you're owed a penalty for that. And rest period penalties. And minimum wage. Did you actually get equivalent to minimum wage for all the hours that you put in? Failure to provide pay stubs. You were an independent contractor. They didn't give you a pay stub setting out all of the wages you earned each 2 weeks. And then, of course, there's waiting time penalties of 30 days of pay because they didn't give you all the pay that you were owed upon termination. And there's reimbursement of expenses. Think about all the expenses that you incurred while working as an independent contractor. If you weren't reimbursed for those expenses, they owe you that. And finally, they owe you because we're gonna file a claim that you were wrongfully terminated. We're going to file a claim that you were discriminated against. We're going to come up with something so we can go for the maximum damages. So it's very, very important to make sure that you avoid practices that create liability. And here's some of the ones that I've seen pretty commonly. First, a lot of employers have a practice of, we need to hire somebody, but we're not really sure whether or not we want to hire them permanently. So I know, let's make them an independent contractor for the first 3 months, kind of like their probationary period, and then we'll see if they work out. If they don't work out, we'll just let them go, no harm, no foul, no unemployment, no worrying about wrongful termination, etc. And then the employee completes that 3-month period as a quote-unquote independent contractor, and then they're just converted to employee status. That is going to lead to liability because the courts are going to say, look, you got somebody who was doing the exact same job under the exact same conditions. It's just that you called them an independent contractor for 3 months. That looks like employment. Another thing that a lot of employers do is you have somebody who's laid off because of reduction of force, or they retire, but yeah, they're still a valuable person. I know, let's make them an independent contractor. Let's bring them back as an independent contractor, and they're doing the exact same thing that they were doing while they were employed. That looks like employment. It doesn't look like independent contractor, and therefore the courts and the administrative agencies are going to be more likely to say, now this is just using the name independent contractor. That person really is an employee. Here's another common thing. Sometimes what employers do is they'll say, hey, we just need to hire somebody for a set period of time. And because we're only hiring them for 3 months for this particular project, they must be an independent contractor. That's not necessarily the case. Temporary employment can still be employment. Now, of course, if you're hiring somebody through a temporary agency, that's a different ballgame. Now that temporary agency is the employer. That person's still an employee. But if the employer is bringing somebody in directly and they're doing work that's core to the business and they're doing it for a set period of time, but the employer is controlling how they perform that work and when they perform that work, they're a temporary employee, not an independent contractor. And lastly, you see this very commonly. If the independent contractor is doing the same work that people categorize as employees are doing, it's very easy for a court to say, look, they're doing the same work. How can you call somebody an independent contractor when really they're doing what an employee does? Under the same terms and conditions? No. We're gonna say that this is an employee. So it's important to avoid having independent contractors, at least on a regular basis, do the same work as a regular employee. So let's focus in on, during the rest of our time, the best practices for defending a classification of somebody as an independent contractor. And number one, and I mentioned it earlier, very, very important to have a detailed written independent contractor agreement. I've seen in the past one-page independent contractor agreements that basically says, we agree that the person's an independent contractor and we're going to pay him this, and that's pretty much it. That's not going to be sufficient. You want to have a number of different things in that independent contractor agreement to make sure that you're establishing, especially for evidentiary purposes. Written documents are always more compelling than somebody testifying. So it's one thing for the president of the company in a deposition to say, oh yeah, he was an independent contractor, here's what we agreed to, and here's what he did, etc. That can be picked apart. But a written document signed by both parties, that's going to be more compelling. So you want to make sure that you've got acknowledgement of independent contractor status very clearly spelled out in there, stating that the parties agree the person or the company that's being retained is not an employee, is not entitled to any employee benefits, is not entitled to be covered under workers' compensation, et cetera, et cetera. You also should have a specified term. Independent contractors are generally hired for a specified term. Now that could be 1 year, that could be 6 months, that could be a 2-week project, but you don't want to have an open-ended independent contractor agreement if you can avoid it. Now, if you have a specified term, basically you can have a clause in there that says if the parties don't terminate by the end of the year period, the contract rolls over for a year. That's fine, okay? But you should have something in there that says that the contract is only terminated upon notice given by one party or another with some sort of period, whether that's 30 days, whether that's 60 days, whether that's 90 days, something to distinguish from at-will employment. Because at-will employment says, essentially, you can be terminated at any time for any reason, no notice required. So in order to distinguish that, you want to have a clause in your independent contractor agreement that says parties can terminate with 30 days written notice, 60 days written notice. Also, you want to have language in there, very detailed language that talks about all the insurance that the independent contractor has to maintain. Workers' compensation insurance for any people they employ, general business liability insurance, automobile insurance. And you should put in your independent contractor agreement that the independent contractor is required to show proof of insurance to the company. That way, once again, from an evidentiary standpoint, you're establishing that this is a bona fide arm's length transaction. You want to obtain evidence from the independent contractor that they seek business from the public. You want to get business cards, advertisements, Craigslist postings, marketing materials, websites, something from the independent contractor at the outset that shows they hold themselves out to be hired by other companies. That's important evidence as well. Next, you want to obtain evidence that they perform work for other companies. Ask them for an invoice they sent to another company. That's important. That's helpful if you have to defend it down the road. Don't require your independent contractors to perform services at the workplace if they can be performed elsewhere. Don't require the independent contractor to come in every day, or if they can perform that work at home, certainly they should be allowed to perform that work at home. Don't require any type of oversight in those situations. Don't require them to use your timekeeping system. You don't want to have independent contractors punching in and out. Next, don't have your independent contractor report to a supervisor or manager. You don't want to have any documents floating around that says the independent contractor has to report in every week to a manager or supervisor or anything to indicate that they're being supervised. Next, don't have your independent contractor sign employment documents, whether that's an employee handbook, confidentiality and non-disclosure should be in the independent contractor agreement itself rather than a standalone form, especially if it's the same form that you give to employees. And you certainly don't want to have them fill out the I-9 form. Again, that is an indicia of employment status, of employee status. So don't have your independent contractors sign employee documents. Have separate policy documents for your independent contractors. I'll give you one example. A lot of employers have a sexual harassment policy in their handbook, which you have to have that. It's important. Okay? As we talked about previously, independent contractors are covered by the sexual harassment laws. So you should have a separate sexual harassment policy that you have your independent contractors sign off on. Next, require written invoices from your independent contractors. They should be invoicing you on a regular basis, every 2 weeks, every month. It should be something that's got their logo, their address. Even if it's a QuickBooks invoice, something that they are sending to you, and then your payable department generates payments, not your payroll department. Your accounts payable generates those payments just like they would for any other vendor. And you want to have your payments going to an entity with a federal employer identification number, not paid out to that individual employee. They should have a separate EIN for payment. If possible, pay on flat rate, pay on a flat fee basis. With a lot of independent contractors, they charge hourly. That's not out of the ordinary. But the more it looks like they're an hourly employee, the more chances somebody can claim they're not an independent contractor. So if you can structure your independent contractor arrangements so that there's an opportunity for profit and loss. In other words, if they've got a particular project that they're going to be doing and it's a flat rate of $2,000, then it's up to the independent contractor to get that work done as efficiently as possible, rather than, hey, I'm going to bill you $50 an hour and it's however many hours it takes me. That looks more like employment. Keep all transactions with your independent contractors at arm's length. Okay? If your independent contractor's using tools and equipment of the company, maybe there should be reimbursement from the independent contractor to the company for use of those tools and equipment. Don't front independent contractor costs and then deduct them from payment. Once again, that looks more like an employment relationship. When the employer is fronting costs to that independent contractor, you're better off having that independent contractor pay for those costs themselves out of the payment that they receive from you. Make them go cash the check. Make them go deposit it in their bank account. That looks more like independent contractor status. Don't have your independent contractors hold themselves out to the public as an employee. For example, if they're wearing a company uniform, that makes it look like they're an employee. Independent contractors shouldn't have company uniforms. They shouldn't have business cards that say basically that they're an employee of the company. If someone's got a business card with your logo on it, your telephone number on it, everything indicating they're employed, that's going to be used against you as evidence. So it's not a good practice to give independent contractors business cards. If you have to give them a business card, have them have their own business card and have your logo at the very bottom, much smaller than their logo or their information. Next, don't evaluate the performance of independent contractors or issue discipline to independent contractors. Independent contractors should never get a written warning. Independent contractors should never sit down for a performance discussion. Look, when you have a contract with an independent contractor, the independent contractor agrees that they are going to perform all those services to your satisfaction. If they're not performing it to your satisfaction, you terminate the contract. You don't write them up. You don't have a performance discussion. You don't have an evaluation. And then finally, don't require your independent contractors to work a set number of hours or days per week. As I said earlier, completion deadlines are permissible, But once you start setting a schedule for an independent contractor, it certainly looks like they're an employee. And as you can tell, as we were going through all of these best practices, a lot of this is based upon what does it look like? What does it feel like? I mean, the courts, as I said, really don't have black and white rules here, okay? So let's talk about some of these questions. First of all, here's a question. We hear so often that a company lays off workers and then you hear that they are being hired back as ICs. You mentioned that's really not the definition of an IC. How do large companies get away with doing this? Well, a lot of times in the past, large companies have got away with doing this because there hasn't been laws like that labor code section that I referred to that just went into effect. Their potential liability has been low. So a lot of companies made that a practice. Now that the IRS and the EDD and the Franchise Tax Board are looking more closely at this, now that there's potential liability for employers that's much greater than it was before, you've seen that practice become less and less frequent. Now, as I said earlier, just because that person was previously an employee doesn't necessarily mean that they can't be an independent contractor. For instance, if they're hired back as an independent contractor but they're doing something different from what they did as an employee, you've got an argument there. And a lot of large companies are willing to take that risk. Next, we have a question. What if you have an employee, W-2, that is 100% paid on commission, and you have a separate sales producer contract that specifies their commission percentages? Nothing wrong with that, okay? Employees can be paid on commission. They can be paid through a separate, in fact, it's important to have a written commission agreement. Having commission payment or a written commission agreement does not make them an independent contractor. So you can still have somebody who is an employee under that type of employment arrangement. Next question. How can employers legally reverse the fact that they had an IC sign an employee handbook because they wanted to make sure they understood the sexual harassment policy? Okay? Here's what I would do in that situation. I would come up with your separate sexual harassment policy, okay? I would have the independent contractor sign that sexual harassment policy, and I would have that independent contractor sign a new independent contractor agreement that explicitly disclaims any prior agreements between the parties. That way, you knock out that prior signature on the independent and the employee handbook, excuse me. So that's how you can kind of reverse that and protect yourself. Next question, business cards. My sales guys that are ICs and qualifies as ICs in every other aspect have business cards that match our company cards. Is this a problem moving forward? As I said, these are all best practices. If the sales guys meet the independent contractor criteria in every other respect, it's not going to sink you just to have them with business cards the same as the companies. What I'd suggest as something to just kind of protect yourself is have their business cards be something a little bit different than what the company business cards look like. Maybe have the logo of the company be a little bit smaller. Maybe have the business card say independent sales representative, something to distinguish them from the regular employee business card. Doesn't have to be major, but just something that'll help you defend down the road if somebody claims, I wasn't an independent contractor, I was an employee. Look at my business card. Now, as I said, if you've got everything else buttoned up in terms of their independent contractor status, just the fact that they have a business card is not going to lead to liability. But best practice, have something to distinguish it. Okay, do we have any other questions before we close out our webinar this morning? Okay, well, a couple of things before I let you go. First of all, if you would like a copy of the slides, the presentation today, feel free to send me an email. I'm glad to send you a PDF with a copy of all the slides. Secondly, you'll see up on your screen my contact information. If you want to shoot me an email with any questions about today's webinar or anything else, please feel free. Glad to answer any questions that you have. And then finally, please be on the lookout for invitations for our webinars in 2015. And please, if you have any suggestions for any webinar topics, we'll be glad to address them. We are going to be holding a live seminar at the beginning of 2015 on the new laws here in California, including the new sick leave law, which is going to have a big impact on employers next year. So if you're interested in attending that live seminar, please shoot me an email and we'll make sure that you get an invitation. I want to thank Gary and BMR for having us have these webinars, and I hope you find it helpful. And please, 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 if you have any questions, shoot me an email. Thank you all for attending. We appreciate it very much.